Thank you.
Okay, can I respond briefly on that? We agree with you exactly. It's ambiguous. We're just assuming, based on case law, that the definition of nonviolent offense will be defined pursuant to 667.5c, but we don't know. That's one of our criticisms, is it's ambiguous. The other misnomer is that only the early parole is limited to nonviolent offenders. The other half of the provision, which is more expansive, is the credits portion, which is unlimited. Currently, murderers are statutorily ineligible for credits. Violent offenders are statutorily limited to 15% good time credits. This initiative throws those statutes, which the legislature has enacted and have been on the books since the early 90s, out the door. And we're going to have violent offenders, murderers, sex offenders, rapists eligible for good time credits in an unlimited manner. It just says CDCR has to develop regulations. So that portion gets overlooked, but I think is even more expansive than the early release for quote-unquote nonviolent offenders. Thank you.
Thank you. Mr. Leno?
Thank you, Mr. Chair. Could I ask a question of Mr. Soderberg, please?
Sure.
I know that you had answered a question to Senator Hancock earlier that, if I heard correctly, about 3/4 of our inmates currently are determinately sentenced.
Correct.
We also hear, I don't know how accurate it is, but the figure 90% of all our inmates will be returning to our communities at some point. Is that somewhere accurate?
I believe that's accurate. The difference between the two is that the 75% doesn't include lifers, and so lifers are eligible for release. It's just unclear whether they would be.
And then I'll follow up just with a statement, not so much a question of the panel, but just with a thought. So as we have this debate back and forth about who's violent, who's serious, who's not, the folks that the panel before us are saying are indeed violent, are indeed serious offenders, and will be eligible specifically for good time credits, they're coming out anyway, unless they're there without possibility of parole. 90% includes many of these people that we're talking about right now, and I see the district attorney shaking his head. So just wanted to clarify that. Thank you, Mr. Soderberg. So again, we're not going to resolve our differences here today, but the reason I'll be supporting this is with recognition that some of these very disturbing folks who are in our system now are going to come out. So the question isn't whether we want them to come out, but how we want them to come out. And I think, and I know this is the governor's thinking here, that to incentivize these folks while they're in our system, to give them some reason, some incentive to begin to look inwards, to begin to understand why they're there, how they got there, and by participating in education, in drug treatment, in alcohol treatment, dealing with all of their issues, that the hope that when they come out, and they're coming out, they're going to come out with some greater consciousness than they are otherwise. And that, I think, gives us some hope for greater safety. This does not in any way diminish the tragedy of your family, Mr. Klass. And as policymakers, we know there are always going to be the exceptional, and we can't legislate around everything. But again, I think it's worthy of recognition that almost all of these folks are coming back out. How do we want them to come out? And right now, there's little incentive. They've been hanging out with each other in very violent situations, surrounded by drugs and not so much alcohol, but surrounded by drugs and violence. And they're coming out. To the degree that we can infuse something new, something different, some incentive, I think is of value. So I'm not looking for a response, but of course you're certainly welcome to one if the chair wants one.
Okay. I know Mr. Monning's come back. I didn't know if he had any questions before we wrap up and go to public comment.
I do have one, if I could.
You had that look.
Yes, well, I apologize. It perhaps has been answered or clarified, and I apologize. I had to go vote in another committee, but I do appreciate the service represented here and the concerns and perspective shared. As I heard the framing from the district attorney from Merced, correct?
Yes, sir.
Yes. I heard several references to the bill resulting in the release of or parole of certain classes of prisoners, but is it... Well, that's what I want to clarify.
Yeah.
My reading of the proposal is that it would create eligibility for parole consideration, but there's nothing in the proposal that mandates release. Is that correct?
Pardon me? Well, except for the credits portion, which is the back end of it, which is
Might reduce the sentence.
might reduce the sentence. And you're exactly right. There is nothing that mandates the release of people that are eligible, but the entire purpose of this initiative is to release or to reduce the prison population.
Right.
So what I think is a fair interpretation and a fair implication of that to understand that there is going to be a premium on releasing people. The whole purpose of this is to comply with the federal court order. And when we met with the governor, several of us met with the governor, and we told him flat out, you know, with all due respect, Governor, I would rather have the federal Elwood Louie, who is I forget the receiver, who, in the absence of achieving the population goals, would be given the responsibility of reducing the population. I would much prefer to leave that task to Mr. Louie than to enshrine in perpetuity in the Constitution of the state of California an initiative as flawed as this one is, as vague and ambiguous, because Mr. Louie is also going to have a process. He's not going to just eeny, meeny, miny, mo
Right.
release inmates. He's going to have...
Right. Good. Well, I appreciate that. But again, I think it's important for the public and for people considering potential implications of this that while it may make a broader class of inmates eligible for parole consideration earlier than they would be under the status quo, they still would have to secure the approval of a parole board review, and that would not be automatic.
Yes.
Some may benefit from an earlier release. Others may be determined not to be fit for release. Is that correct?
You're correct, Senator.
Thank you very much.
Ms. Hancock, did you have any questions?
I think they've been asked.
Okay. And so I also want to thank the DAs, ALADs, and of course, Mr. Kloss. We always want to hear your voice. It's very important that we hear from you. You know, I got here in 2012, and my first assignment was to be the budget chair of Budget Sub 5. And I noticed early on that we did nothing for rehabilitation. We had totally eviscerated that whole operation. Not because we really wanted to, it's because we had 10 years of really horrendous budget cuts. I'm sure you felt it.
Yes, sir.
On the law enforcement end, too. And so when the overcrowding started and we were forced to let people out or push them down to the county level, I don't think we really had a well thought out plan. And I think we knew what we had to do, and we did the best we could as quickly as we could. A more well thought out plan, I think, is what you see now in Prop 47, where you say to yourself, how do we release these individuals in a way that makes sense? Where we can educate them, get them drug rehabilitation, where we can get them out of criminalization, how we deal with their mental health. And we create a holistic way of dealing with them. We started that process with Prop 47. We're still working through that. Even now, I think you heard earlier, we even had a discussion on whether it's $29 million or $150 million. We're just now funding it, funding rehabilitation. And you're absolutely right, it takes time. But more important, we have to do it. At some point, we have to start rehabilitating people who, as as the members of this committee have said, they are coming out. And whether you want them to come out totally criminalized in the system, or whether you want to try to find an avenue in which they become better citizens and they can feed their families and be productive members of our society. And I believe that as we now move there's a concerted effort from the proponents of this to try to not just do this thing of rehabilitation, but looking at it in a broader sense. And I believe we're working toward that. To our colleague here, this process of having hearings is also new to me. I'm not blaming anybody, but it did come from the Senate. And but I also think it's a good idea. Having an open dialogue where we invite everyone and they can attend or not is I think the only thing that this chair and this chair are committed to is to invite everyone that's involved in this, and then they can make up their mind to come to this hearing, this one hearing, and hear all of the issues. But most important, not only just for us here, but for the residents of the state of California, so we have a full hearing, because I think that what was missing before. If we didn't have this process before, we were just going straight to the ballot and straight to the campaign. And so I do see the merits in having this, even though it's very time consuming. And so I think our responsibility, we fulfilled it, and we've allowed people to have a hearing, and in a little bit we'll hear from the public, because I want to make sure we have time to hear from them. And so we've basically fulfilled our commitment to hear it, and I think hopefully you believe you've been fully heard, and hopefully the proponents have been fully heard, so that we can go ahead. And I want to thank you for coming here today, because it's very, very important to hear from you. And I genuinely feel your concern, and I think every member on this panel feel law enforcement's and the DA's concerns about this is not being taken lightly.
Thank you, sir.
So, thank you. Did you?
I would just like to add my thanks, and I'm very grateful that you also gave us that additional information, and I think it's been a good discussion.
Thank you, Senator.
Thank you. Now we're up for public comment. Start with the proponents.
Mr. Chairman, may I ask a question?
Sure.
Was the governor or his representative invited to participate with us today?
Yes, everyone was invited, including the governor's office. Yes.
Great. And can we extend to him a request that we certainly would welcome any clarifying comments he wishes to make based on the conversations and testimony that's been provided to us?
Senator, I think that would be fair to ask that.
Thank you.
Good morning. Thank you. My name is Erica Webster, and I'm from the Center on Juvenile and Criminal Justice. I just wanted to address some statements regarding the crime trends that some individuals on the opposition's panel made about realignment in Prop 47. So over the past few years, our organization has conducted some studies regarding the question of whether or not releases from prisons as a result of reforms
sorry, got 1 minute.
Okay. Have caused an increase in crime. And so what we've done is look at releases from prison as a result of realignment in Prop 47 at the local level, and found that there's no relationship between releases from prison and resulting increases in crime. In fact, several counties looking at Prop 47 actually experienced decreases in crime: Solano, Contra Costa, and San Joaquin, just to name a few. So in regards to California experiencing a crime increase, if you look at the local level, there's a lot more variation. Thank you.
Thank you.
Me. Could you, to the witness, I think I would like to see a copy of your report.
Sure.
Again, additional information is very, very helpful for us. Thank you, and maybe other members of the committee would as well.
Okay.
Thank you.
Hi, good morning. I'm Maureen Washburn, also with the Center on Juvenile and Criminal Justice, here to lend our strong support for the ballot initiative. And I just wanted to highlight the research that Frankie Guzman mentioned earlier in his testimony, the report that most of you have in front of you that was authored by the National Center for Youth Law, the W. Haywood Burns Institute, and the Center on Juvenile and Criminal Justice, and to point out the stark racial and ethnic disparities that we find in the application of direct file statewide. Thank you.
My name is Rourke Stacy. I'm a criminal defense attorney, juvenile law expert, and member of the Pacific Juvenile Defender Center Board. I've represented children in transfer hearings in juvenile court. I've represented children transferred to adult court from juvenile court, and I've represented children that were filed because of direct file. And I've seen the devastating and harmful effects of putting children into the adult system, and more importantly, the devastating effects it has on our community as parents, as individuals who want to be part of working in active communities. When we remove youth and put them in the system, we really do give up on them, and it devastates our communities for years to come. Thank you.
Thank you. Next witness. Or next.
Good morning, Sue Burrell. I'm with the Pacific Juvenile Defender Center. I was one of the people who helped to write the original initiative, and I've got involved in this because I've seen how arbitrary a lot of the decisions are on direct file, and I believe that our state needs a system that provides a thoughtful process for making this incredibly important decision in sending kids into the adult system. But also, with respect to the adult provisions of the initiative, we've got to give people hope, and we've got to give them incentives. Without that, they really lose hope. And I think what Senator Monning was talking about earlier about would this initiative improve behavior, improve the way prisons operate? There's no question in my mind that it would. We've seen that already in talking with people who've been affected by Senator Hancock's legislation in sentencing review. It'll make a huge difference. Ultimately, I think this will help public safety in California. Thank you.
Thank you.
Hi. To be honest with you, 50% of what you guys are saying, I don't understand, and I'm not an attorney or involved in any of this. I'm simple a mom. I wish my son was here, speak for himself, but my son doesn't know I'm here. I didn't tell him anyway. I'm only can speak for as a mom. Who my son is almost 31 now. In 2002, he was 16. He got sentenced to other trial for 21 years. Now he's almost 31, like I said. He has 6 more years to come out. He has a, date that he's coming out. He'll be 37. Now, if he was sentenced to juvenile, I don't understand this law thing, but I'm sure he would be out by 25 years old. And that's almost like half of what he will be served. Mm-hmm. And forgive me if I'm wrong, he will be exhausting $1 million for his 21 years of incarcerated in level 4, where they don't allow any of rehabilitation whatsoever. And he will be coming home age 37 with wearing a shell of a grown man body who never held even a girl's hand. He will come home, he never held a job in his life, with no rehabilitation whatsoever, with the trauma of a child who had to survive in level 4, which is he's still there.
Thank you, ma'am.
Yeah, so do something.
Yes, ma'am.
Thank you.
Thank you.
My name is Sharice Domingo. I'm with Silicon Valley Debug and the California Alliance for Youth and Community Justice. We work with a lot of families, just like the mom who came here today, who have loved ones in the system. We've seen the front end and the back end of kids being direct filed. And we know so much that hope can make the difference of someone coming home. So we support the Public Safety and Rehabilitation Act of 2016.
Thank you.
My name is Cecilia Chavez, and I'm also with Silicon Valley Debug in San Jose, California. But we also work with other organizations throughout the Bay Area and throughout the nation. And just like my colleague Cherise, we witness a lot of families and the collateral damage that happens when a youth is transferred to adult court. And let me just say that these families want their children to be rehabilitated. They accept the fact that they committed an incident, but they could grow from that, and that incident is not a reflection of who this young person is, and that rehabilitation is possible. And through this measure, we believe that more children will get the opportunity to grow and to mature, and for their brains to develop properly. Thank you.
You're welcome. Thank you.
Hello, my name is Khalid Samurai. I'm a policy associate with the W. Haywood Burns Institute, one of the organizations that worked on the report in front of you. And I would like to say that I'm in strong support of the Public Rehabilitation Safety Act. And because of the disparate impact that prosecutorial direct filing has on youth of color. And just to highlight that, in 2013, for every one white youth directly filed, 2.4 Latino youth were directly filed, and 4.5 black youth were directly filed. In 2014, for every one white youth directly filed, 3.3 Latino youth were directly filed, and 11.3 black youth were directly filed. That is on page 11 of the report in front of you. Additionally, a question was asked earlier regarding whether violent youth offenders have a chance to rehabilitate, and if there has been any studies regarding that. The OJJDP, the Office of Juvenile Justice Delinquency Prevention, released a study called Pathways to Desistance that showed that violent offenders, youth who are violent offenders, can grow out of their criminal behavior given the proper interventions. Other research has shown proper interventions are not isolation in jail, not juvenile halls, but rather connections to the community that these youth are from. Thank you very much.
Thank you.
Thank you. I'm Jim Lindberg on behalf of the Friends Committee on Legislation in California. We do strongly believe that people can transform if given the necessary opportunities, rehabilitation, and programming and so forth. We've seen what the emphasis on punishment, where that has taken us over the last 35, 40 years. It's led to overcrowded prisons, extremely high recidivism rates. As Senator Leno points out, we now spend considerably more to incarcerate people than we do, say, for higher education. And we just really think that the purpose of imprisonment or sentencing rather than punishment should be public safety, and that is best achieved through accountability, rehabilitation, and restorative justice. We think this bill is a really, or initiative rather, is a good attempt to make a system that is really relied on determinate sentencing rehabilitative again, so that people can transform. Lastly, I will say that I've struggled with this issue of crime rates, the uptick in crime rates for some time now. And while I've seen studies that say that crime rates have gone up in 2015, they also are quick to point out that this is happening across the country. So therefore, it seems highly unlikely that it could be attributed only to Prop 47 and realignment. We do favor getting rid of direct file as well. We think there needs to be some oversight. This is a hugely important decision. Thank you.
Hello, my name is Jennifer Kim. I'm the Director of Programs at the Ella Baker Center in very strong support of this initiative. I just want to refer back to Chief Butler's comments about how rehabilitation and accountability go hand in hand. I believe that this initiative embodies that. Thank you for your time.
Okay. And are there any comments from any of the opponents? Any of the opponents? Okay. With that, I think we're going to close the hearing. All right.